Okay, so this is going to be the third class. In yesterday's class, we had started preamble, right? So in preamble, we had started. We analyzed the previous year question and we found that there are two type of question UPSC is asking. Type number one, that is they are asking on the features and significance of preamble. Second, they are asking on the keywords which are mentioned in the preamble. With that, we had started to cover this features and significance of preamble. We found that it's also called as the identity card, and then it has been inspired from the US Constitution, derived from the objective resolution which came in which year? Yes, 1946. Then act as a basis for interpretation of constitutional provision, despite it is not having legal enforcement, but it guides the judiciary as well as the legislatures to determine the spirit and the intention behind the different provisions which are there in the Constitution. Then it was included as the end of the Constitution so that it conferred with the rest of the provisions which are there. In today's class, we are going to see about the amendability of the preamble and what are the other features which are there in the preamble by looking at the preamble, like what exactly are there. So let's decide on the first is the amendability of preamble. So there are two judgments of preamble. So the first for this the first question comes is that whether preamble is part of Constitution or not. Is it the part of the Constitution or not? So there are two important judgments regarding this. Number one is the Berubari Union case. First is Berubari Union case. It was 1960, and what it said that the preamble is not the part of the Constitution, because it's not like the if you see that what is the part 1 of the Constitution? What is the part 1? Union and its territory. However, when you see the Constitution, the preamble is there, and then the part 1, part 2, part 3 like that is. So it has not been included as a part of the Constitution. It has not been made as the first part, then this part 2 was the Union territory or the Union and that. Right? So that's why the interpretation was like it's not the part of the Constitution, it's separate. That was the interpretation. More we don't need to go like what exactly. We know the Berubari Union case. It is related to the exchange of enclaves or the territory with Pakistan. Berubari was the territory which we gave to the Pakistan, and that was the case. Then came the Kesavananda Bharti case, 1973. It said yes, preamble is the part of the Constitution. So if it is the part of the Constitution, then it is amendable using Article 368. Yes, you have to use Article 368 in order to amend the Constitution. Preamble. The third case related to this is the LIC of India case, 1995. This case upheld it and reiterated that preamble is part of Constitution. Is part of Constitution. Okay, so this is about the amendability. Yes, it is amendable. Yes, it is part of the Constitution as per the present jurisprudence of the Supreme Court of India. Okay, so this much is only enough to answer the questions related to it. Fair? Now let's analyze this key features again. The other features which within this preamble. Now, if you see the preamble, few things are there. First is that it says we the people of India. We the people of India. It has not said we the Constituent Assembly. It has not said we the political leaders. No, we the people of India. So what interpretation we can draw from that is that the first thing is that preamble says that there is the what is the nature of our constitution is going to be. It highlights this popular sovereignty. Popular sovereignty. That means that the power rests with people. Power rests with the people, not with any political party. Okay, so this is the popular sovereignty, or you can say that the power rests with the people. Okay, this is also showing the source of power. It's also showing the source of power, which is nothing but these people. People are the source of power. Ultimate power rests with the people. That's the first line it is saying. Second, having solemnly resolved to constitute India into. The people of India want to constitute India into what? Into a sovereign, secular, socialist, secular, democratic republic. This is what they want to make India. Okay, so the nature of the state, they are defining. The second thing is that nature of the state. That is, what is going to be the nature? What is going to be this government which we are going to form? It is going to be SSSDR. Please remember this, exactly have to remember. First, sovereign, socialist, secular, democratic republic. Okay, this is the nature of state it is going to be. It is the nature of the state it is going to be. Okay, now next, if you go later, and to secure to all its citizens, it's saying we the people of India, we are going to make our country like this, and we are going to secure. Basically, we are going to secure. That means what we are going to do. So this is nothing but the objective we are saying. Our objective is to secure to all its citizens who are there in this country. What? Justice. First. Second, liberty. Third, equality. Fourth, fraternity. That they want to secure for this country, for the people, for the citizens of this country. Okay. So third is that objective of constitution or state. What exactly objective is? It is JLEF, justice, liberty, equality and fraternity. What exact words are there that we should know, we should remember, that we will cover, because each word we are going to cover. Within that we are going to write, it is talking about social, economic, political, justice, thought, expression, belief, faith, worship, like that. But JLEF, SSSDR, this we have to remember. Exactly this sequence, and the 5 words here, 4 words here are important. Then, in our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves this constitution. Like it's a pledge, isn't it? They're like making a people of India to pledge. Now here, it's about the date of adoption, enactment, right? So it is giving the date of adoption, third or fourth. Date of adoption and enactment has been given in this, and that is 26th November 1949. Okay, so from preamble we are getting 4 important information. What is the source of authority and the power? what is the objective of this state, what is the nature of the state, and what is the date of adoption. These are the 4 information we are getting. Okay. Next comes is that amendments to preamble. Some amendment have made to this preamble. Remember, only once the amendment has happened in 42nd Constitutional Amendment Act 1976. This is the first time it has happened. And what they did is that addition of words. What words? The socialist. First, second, secular, and third, integrity. Integrity. These 3 keywords were added later, okay? It was not the part of original constitution, it was added. So earlier, Indian constitution was implicitly socialist, but now it became explicitly. Explicitly means something which has written specifically, but something which has not written, but still it is reflecting something. That is called implicit. It is something is implicit to the person. So addition of the word like socialist, secular, and integrity was made in this. So if you analyze this preamble, we analyze like this. Authority rests with the people. Nature of the state is going to be triple SDR. The objective is going to be the JLEF. We have to remember that. And the date it is giving. It is also giving that the one time there is amendment. One in here. These two words. And second is that this word fraternity, assuring the dignity of individual and unity and integrity of the nation. These are the amendments. Clear? Facts are there. So these are only the components, like the component 1 where it comes objective and the nature. See this. 2020. What is the answer? D. Part of constitution but has no legal effect independently of other parts. A part of the constitution but has no legal effect. Not a part of the constitution, this can be removed. A part of the constitution and has the same legal effect as no legal effect. This also not there. A part of the constitution but has no legal effect. A part of the constitution but has no legal effect independently of other part. This makes more comprehensive definition of the preamble in this sense, because certain terms like let's say secularism. Yes, it doesn't have the independently meaning, but when you see the secularism word with relating with the fundamental right, Article 25, 26, which talks about the secularism, then it becomes legally enforceable, right? 25, 26. So option D is going to be the right answer. Next. Does it incorporate the fundamental rights? The words are there, but are they fundamental rights, or are they saying that these are the objectives we are going to achieve? It's not saying that we are going to give the rights to the people. So fundamental right by definition has the meaning that these rights which can be enforceable. So then only you call them fundamental right. Otherwise, rights are in many places. Not every right we say as a fundamental right, isn't it? So in preamble also something is written doesn't make them the fundamental right. For example, if you say that the right to property currently not in the part 3, it is in part 12. But that is also right, not fundamental right, it's constitutional right. So whether the option 4, that is the statement 4 is correct or not, I think it would be incorrect because it incorporates the fundamental rights of the citizen of India. I think it doesn't have that exact word. And if you compare with this, it is saying that the independently of other part, it is making it more comprehensive definition. However, it has vaguely said that it incorporates the fundamental right. If it is saying that the preamble incorporates the essence or the words like which are there in the fundamental right, then it makes some sense. But direct, if it is saying this is complex interpretation, so we should not go as correct statement this one. Rest of the things are correct. Yeah. Next is the second. We'll go to the second micro topic, that is keywords. So here, how many keywords we identified? Keywords, what we have identified till now, we'll go like this only. First, S, D, R, J, E, L, F, unity and integrity. Now every word we know here. Sovereign, next, socialist, secular, democratic, republic, justice, equality, liberty, fraternity, unity and integrity. How many words are there? 5 plus 5, 10, right? Total 10 keywords are there. We'll cover one by one. Okay, let's start with this sovereignty. So we will understand the meaning only. Why? Because here what kind of question is expected is that which among the following statement best describe, best defines this keyword. Like that question they can come. So we need only the key, how in what ways it can be defined. So sovereignty, one way it can be defined is that there is absolute authority of country and its people to govern themselves. Isn't it? They should be able to govern themselves. It should not be like the other people, other country people are governing us. Then sovereignty is not there. The second way of looking at is that no external interference. The external interference is not there in our internal domestic matter. Interference in domestic matters. Okay, these two are one is that we should be independent of taking our decision. We have this absolute authority to govern ourselves. What decision we are making for our country, it's our business, none of the business of US or other country. Similarly, no external interference should be allowed in our domestic matters. They should not interfere. These two mean. So recently some issues are happening. For example, China, Pakistan is occupying our some territory. This is the violation of our sovereignty, you can say. What sovereignty? territorial sovereignty. This is the territorial sovereignty they have violated. Similarly, when this CPEC goes through our country, that is POK, currently occupied by the Pakistan, it is going through that without our permission. It's also violation of our territorial sovereignty. Not required, this is just to understand the context. Next word is socialist. It has certain meaning. Socialist means, see, we know what the socialism mean and what is the essence of it. But how it can be defined, I mean, the what manner it can be defined. The number one is that there should be social and economic equality. Social and economic equality is the one way. Second, it strives to ensure social justice. This also keyword you will get. Social justice means there is lack of discrimination. Justice means what? Fairness. When the fairness is there in the society, it's social justice. For example, the women are also getting the equal chance to get in the career. That's the justice, fairness towards the women. Since women is the part of the society, it's called social justice. Second, its goal is to ensure welfare state. Ensure that there is welfare state. Then there should be equality of opportunity. There should be equality of opportunity. It is implicit, this socialist word in Indian constitution is implicit or explicit? Is it implicitly mentioned or explicitly mentioned? Explicitly mentioned. But did the original constitution had the explicit mention? No. So you write original constitution did not explicitly then 42nd Constitutional Amendment Act mentioned it explicitly. So currently it is explicit. Earlier it was implicit. Is the socialist word is defined in the constitution? Not defined in Constitution of India. See, most of the words in the Indian Constitution has not been defined. The reason is that, see, if they define, let's say, in 1950s, their definition keep on evolving. So if they will make the rigid definition, it will reduce the flexibility and then again the living document nature of the constitution. So they prefer not to define things. They kept it like this word only. Now, it is saying it has not been defined, and this kind of question UPSC asked. Last year they asked like whether the political party word is mentioned in the constitution or not. 2025 question. So like this we should be aware. Recently their case happened. The case challenged this word, the validity of the socialist word in our constitution and that in the preamble. Why? Because the India is now moving towards a more, what do you say, that the more kind of capitalist, right? Look more liberal, more capitalist. So the socialist nature is declining. We are privatizing our PSUs and that is happening. So many challenge this, like it doesn't require. And there is a famous case recently happened, that is the Balram Singh case. Balram Singh versus Union of India case, 2024. This case is important, in which this word, two words were challenged. Words socialist and secular. Their validity and presence in the preamble was challenged. That it doesn't require. But you know, this Balram Singh case, Supreme Court said it is required. Their validity is upheld. upheld these keywords. And what Supreme Court said in this particular case is that the socialism doesn't mean the communist socialism. Indian socialism is democratic socialism. Not what? Marxist, or you can say the communist socialism. As you know, socialism has different forms. Communism is there, Maoism is there, Leninism is there, so many ism is there, right? But we have followed the democratic socialism, where the democratically elected government is ensuring the socialism, not like the autocratic. The second way of Indian constitution, the Indian secularism, it is a blend of Gandhian plus Marxist. Gandhian is more democratic, Marxist is more communist. So Indian socialism is the blend of this. However, heavily inclined towards which? Gandhian. Heavily inclined towards Gandhian. So very important keywords are points are here. We should remember them. Okay, so these are the socialist economic equality, social justice, welfare state, equality of opportunity. Original constitution did not explicitly mention, not defined in the Constitution of India. Balram Singh case is related to this. Indian socialism is democratic socialism, and it is blend of Gandhi and Marxist, inclined towards Gandhian. I don't think any other than this is required for the prelims. Enough to define it. Next word is the secularism. Okay, secularism have certain meanings. So if you see the meaning, different how we can define the secularism. One is that, number one is that no state religion. You should not have a religion of your government. Government doesn't have its own religion. Second, equality of religion. That is, every religion is equally treated. Okay, no discrimination. Equal treatment of all religion. You cannot discriminate. No discrimination. Based on religion. Okay, so same words can be interpreted in many ways. For example, in Indian Constitution, Article 15 clearly says you cannot discriminate among the citizens based on the religion. Yes or no? Right? That is there. And then equality of religion should be there. That is you treat all religion equally. Don't prefer one religion over the others. That is there. Third aspect is the freedom of religion. That religion gets the freedom to preach and practice their whatever practices they have. They have this conscience freedom and everything. So the freedom of religion to practice, it is there in Article 25, 26, 27, 28. Even 29 also tries to protect the religious minorities. Freedom of religion, no state religion, equality of religion, freedom of religion. These three aspects are important whenever you see, right? Now, this is the meaning of the religion. Now, when you see now other features, let's say secularism, Indian secularism, what is the feature of Indian secularism? This is general secularism. There should not be any state religion. Equality of religion should be there. Freedom of religion should be there. Right? That's for any country, secularism. Now, what Indian secularism is that? First is that it is explicitly mentioned. Mentioned in the Indian Constitution only through 42nd Constitutional Amendment Act. Second, it is not defined in Indian Constitution. Third, it is a basic feature. Which judgment said this? S.R. Bommai, you remember? S.R. Bommai 1994 said it's a basic feature. We already discussed in the basic structure. Now, Indian secularism is the positive secularism. That means we need to know what is the positive and what is the negative secularism. Now, the positive secularism against negative secularism of West, like France. Now, what is a positive and negative secularism? See, the negative secularism is something when the state and religion are completely separate. However, when the state and religion are having certain influence, then it is called as the positive secularism. See here. Here there is influence of state and religion. This is state and religion, complete separation. Here what happens is that state tries to reform the religion. Here state cannot interfere in the religion. Religion cannot interfere in the state. However, here the state can bring the reforms in the religion. They can promote a religion. They can reduce the discrimination or anything which is wrong is happening in a religion. For take example of triple talaq case. How can state enter into some triple talaq which is religious? How can state enter into Sabrimala case? State means the judiciary. Because they can enter. It is the positive form of secularism where state can promote the religion. For that they can enter into the domain of religion. However, in the France they cannot do that. Right? And that's how you see that in India, in the France bans the hijab for the French athlete in 2024 Paris Olympics. They banned it. This shows that there is a negative relation between the state and religion. However, here we promote. We allow the hijab in these all practices. Except some cases happen, hijab ban case in Karnataka and some special cases. Overall, it is allowed. We are celebrating Diwali. Government is giving holiday on Diwali. Government is giving holiday on Christmas recently. Government is giving holiday on the Eid also. What that signifies is that government is not discriminating between one religious festival against the other religious festival. But there are minorities in the Pakistan also, Bangladesh also. Will they get holiday on the Diwali, Dasara, Holi? I don't think so. Because they are not, you can say that the secular, more theocratic, or they are having the complete separation. In France also, there are Hindus, but will they get that holiday on that Diwali, Dasara? It's difficult. Right? So, that is the difference between them, positive and negative secularism. This much just to understand what is the positive secularism and there is state and religion are having the relationship. This much is enough, right? For the notes, do we need the explanation to write? Not required. We can read ChatGPT is also there. It will help. Next word is the democratic word. Whenever this demos word come, that is the democratic word come, it simple means that there is when the power rests with people. So when the people are in the center. So whenever UPSC gives any statement where they have asked us to define which among the following is the right definition of the democratic word, try to see in that statement whether the people centricity is there or not. Okay, so here what is important is that the people centricity, and that was the famous definition by the Abraham Lincoln also. Na? It is the form of government which is for the people, by the people, and of the people, all of like, right? So that is the democratic, like the Abraham Lincoln also has defined. The people should be at the center. Now, what is the Indian democracy? How we see this democracy? First, we have this parliamentary democracy. Second, we have representative democracy. Representative democracy. That is, not the directly people are ruling. Ultimately, people should rule. Ideal condition, people should be the one who should make the law. But since that's not feasible, we send our representative. So Indian democracy is the representative democracy, a representative democratic state. Right? So this we know. For example, Lok Sabha, Rajya Sabha, we send what? MPs. That is the example. MLAs we send. Those are our representatives. Now, another feature of Indian democracy is the decentralized democracy. In the form of 73rd and 74th Constitutional Amendment Act 1992 that try to decentralize the democracy. Clear? This much is enough. Now, there is one concept we should be aware about here. That is, when we say that there is representative democracy, what is the other form of democracy then? What do we call that? There is representative democracy. What is the other form? Parliamentary presidential democracy. One, yes, what do we call that? Exactly that. That is called as the direct democracy. Isn't it? It's a direct democracy, like Switzerland. So, direct democracy is something when instead of representative, peoples participate. People participate in government. Now, there are certain tools where the question can be asked. Tools of direct democracy. Tools of direct democracy. Okay. Here there are certain tools which we should be aware. Tool number 1 is called a referendum. Yes. Referendum. First is referendum. Referendum means when the decision is put in front of the people. Okay? Decision by people through voting on any issue. For example, take example of this Brexit. Brexit had this referendum. So whether Britain will separate from the European Union or not, it was not decided by the Parliament of the Britain. They said, let's put it in front of people of Britain. Let them decide whether they want to be with the European Union or not. What result came? Result came that the 48% of the people said we should remain with the European Union. However, 51.9% of the people said we should leave the European Union. So finally, what is the decision? They have to leave it. So that's why the Brexit came. So this is an example. Brexit is an example of referendum. Britain exit from European Union. Second keyword is plebiscite. Plebiscite. Plebiscite means like here we want the opinion of the people. On an issue. Here it is, see, the two difference is that here there is decision we are seeking. We are not seeking opinion. We are seeking the definition, decision, direct question. Here see the direct question is there. The proposition of the ballot paper, what it said, should the United Kingdom remain a member of European Union or leave the European Union? Direct question, yes or no. We are not seeking opinion of the people here, right? But in the plebiscite, we seek the opinion. We seek the opinion of the people on an issue. That's the plebiscite. Okay, this is the plebiscite. And third is initiative. Initiative means initiate the law. Or you can say bill. To make a law, you can initiate a bill. We cannot do here in India. Can we start a bill? Not possible. We have to go through our representative. Fourth is recall. Recall means to call. Okay, so the four tools of direct democracy, very important. Question can be asked, match the following can be asked here. Okay, yeah. Next. These are not important. This example we saw. Next word is a republic. See, any government, if you see earlier, the middle age of Europe, West or India also, there were two forms of government were there. One is the monarchy, and then later they transform into republic. Now, when we know that earlier there were monarchy and then later they transform in the form of from monarchy to they become the republic. What exactly happens here? Here, in terms of monarchy, there is special and privileged class. Privileged class in a society. However, here there is no privileged class in the society. No privileged class. Okay? That means when it says the privileged class, these privileged class people have, you can say that the hereditary right over certain public you can say the public post or public offices. However, public offices are open to all. Okay, this is open to all. Then the political authority, the political sovereignty, we call that the head of state, rests with that monarchy, the king, but here it rests with public people. That's called as the political sovereignty. Here the political sovereignty in the form of head of state is king or queen or some form of monarch. However, here political sovereignty rests with the people. So this way you can define or differentiate between these two, that is what is monarchy and what is republic. Now here example also we can give. Example here is Britain. Here example is India, US, right? Clear? So three things are there. Yes, privileged class should not be there. The public offices, even the president is open to all. Women, tribal president we are having, right? So that means it's accessible to everyone. Political sovereignty should be with the people. Then you call it as republic. Now this you see Britain and India. Now here some other feature for the Indian Republic we need to have. The Indian Republic. What is the feature of Indian Republic? Now the first thing, republic term in preamble. We have taken from, remember this, French Constitution, French Revolution is the inspiration and we have borrowed from them. This word we have borrowing on a chapter, we have covered this. French, Indian preamble came from the French. In term, this word republic in preamble has been taken from this French Revolution. The second thing is that what form of republic we are having? The head of state, who is the president, is indirectly elected by people of India. So the citizen of India. This is better word. Citizens of India. Indirectly elected by the citizens of India. Okay. So this is the Indian form of republic. Any other point? No, not missing. Next word. Is done? Understood this part? Republic. Next is justice. Whenever this word justice is coming into the picture, justice, try to see certain meaning, the meaning. What you try to see, the essence of justice is in the fairness. There should be fair treatment of the people. Then you say the justice. So when I say that the fairness, it means that there is fair treatment. Without biasness. So here use this word reasonable biasness. What is the meaning of reasonable biasness? Will come into this. Second term you will find is the impartiality. Individuals or groups, you should have this impartiality word. Justice. The third thing, you see the types of justice here. Types. Now types can be different types. Number one, there can be social justice. Social justice, that means equality. There should be absence of discrimination in society. Right? There should not be the discrimination, like abolition of untouchability is justice. Right? So social justice, that is equal opportunity and the absence of discrimination. Equal opportunity and no discrimination based on caste, religion, etc. That's the social justice. So social justice, equal opportunity, no discrimination based on caste and class. Now this can also be in the form of social justice. The second can be economic justice. That means the economic benefit should be given to or the fairly distributed. There should be lack of concentration of power. Concentration of wealth. Concentration of wealth and resources. So the wealth, income and these all things are fairly distributed. When we say the fairly, doesn't mean like the equally everyone is having the same resource. It should be the fairness in that. Some people should not get the unfairly more advantage. Third is political justice. Political justice means equal access to get public offices yes, get elected, to vote. Suppose you are discriminating some people not to vote, not to get elected, that's not political justice. Here very important, the fourth aspect is that called as the distributive justice. Distributive justice is nothing but the social justice plus economic justice. Together it is called as the distributive justice. Because the society, you are making everyone equal. Then through economy you are distributing the resources, opportunities among everyone fairly. Through that fairness in the society and economy, you are ensuring the distributive justice. So these are the different form of justice. And in India, that is Indian justice system. What are the key things are there? Number one, we have taken this justice word in preamble from which constitution borrowed? US? No, this justice keyword. Social, political, economic justice. In preamble, we have this, right? Three word. This justice, three word are there. Social, economic and political. Huh? Russia, yes. You remember that justice and duty. Two things they do, the socialist thing. So, justice in our preamble we have taken from USSR, not Russia at that point of time, USSR. Okay, and in our preamble talks about what justice? Social, economic and political justice. So the question can be, which among the following justice is mentioned in Indian preamble explicitly? So if they give like the social, distributive, retributive, retrospective, political, economic, so many they can give. So remember, only three are mentioned there: social, economic and political. It has been taken from justice, has been taken from the USSR. The philosophical basis is of justice is John Rawls. John Rawls' theory of differential justice is there. Differential justice. What is differential justice? Have you heard this term, differential justice? Differential justice means, see, justice implies that you treat everyone equally, fairly, isn't it? But can you treat a person, healthy person, and one physically challenged person and ask them to reach that 100-meter mark in order to win the race? If a person is having 2 leg fit, another person is having only 1 leg, you are asking them to compete in the same race, same criteria, same distance. It's not fair, right? Fairness is not there. So you can't say that in that case justice is there. So in certain cases, you have to treat this 2 person differently in order to ensure fairness and justice. So what John Rawls says that you treat the differently situated people differently. That is the basis of reservation system in our country. Otherwise, it is violating the equality principle. How can you be partial towards some? How can you be like the fair treatment without biasness, right? But we are biased towards some. We are giving 33% reservation to women. We are giving the SC, ST, OBC, EWS reservations, right? That's impartial towards those who are competing with the general category and without any reservation. But that has been justified using John Rawls' theory of differential justice, which says that since they have been situated differently, their socio-economic status are lower compared to the others, so they get inherently less opportunity to compete. So let's give them certain edge. So when you treat differently different people based on certain reasonable ground, and that's why I have written here reasonable biasness, not like the any form of biasness because you don't like the person. Okay, so that is the differential justice. We will cover more in the fundamental rights because that is where we are going to cover, but just the philosophical basis here we should have covered. Okay, next term, liberty. In preamble, what is exactly mentioned? Please write it first. In preamble, it is written liberty of thought, expression, belief, faith, and worship. Write it. Liberty of thought, expression, belief, faith, and worship. Any mnemonics we can make? Because see, they ask this question like which among the following liberty has been mentioned explicitly in preamble? So here they can give many liberty, right? Liberty of thought, expression, belief, faith, worship, assembly, association, profession, trade, residence, movement. So many liberties are there. But out of so many liberties, which are mentioned in the preamble, remember this: T, E, B, F, W, something. Can you create anything? E, F, B, E, F. I got it. Did you get it? Okay, you create and let me know. I created, but it's difficult to share. It's little odd. I'll share individually later. Okay, liberty. You wrote that? What are there? Belief, expression, faith, and worship, as well as thought. Yes, thought. Okay, these many are there. So what this what Telangana education board for women. Oh wow. Thought, expression, belief, faith, worship. Is it in the sequence also? Oh, see. Yes. Now, here, whenever this liberty word comes, the meaning which comes in our mind is what? Freedom, isn't it? So there should be a freedom. There should be freedom. Second is, there should be absence of restraint. One thing is saying that I am free. Second is, there is absence of restraint. That is, nobody is putting any kind of restraint or any kind of obligation or restriction on me. So absence of restraint means no restriction. These are the literal meaning. Okay. However, the Indian liberty doesn't say that it's complete freedom. It's complete absence of restraint. There is reasonable liberty. Reasonable restriction on liberty. That means no absolute freedom or the liberty. No absolute freedom or liberty, reasonable. So this liberty, that is a freedom, balance with plus what you can say that the social harmony is something we want. If something is saying that we have the unlimited power or the freedom to do anything, no. Our freedom should be balanced with the social harmony. Right? We cannot say anything. If it is disturbing the society, it is not allowed. So these are the different interpretations can be made of liberty. Then there are two forms of liberty, two types of liberty are also there. That let's cover. So one is that types of liberty. What types? Number one is that the positive liberty, and second is called as the negative liberty. Positive liberty and negative liberty. Now, what is the meaning of positive liberty? The meaning of positive liberty means that, see, if I say that women have the liberty to walk freely on the roads even in the night, do you think it is there? We have given the liberty, right? One way we call that as the formal liberty, formal freedom, formal rights. That is, on text it is available that women can walk freely on the road. So, if you see this, that is called as a formal justice, also formative justice. So, what is said that the formative liberty means that women can walk freely on roads at night. This is a famous quote also. I consider freedom when the women can walk freely on the roads at night. I think Gandhiji or Ambedkar, someone has said this. Now let's take this example. So this is formative liberty. No law is restricting that the women cannot walk freely on the road at the night. Any law is there? No, right? So formally we have given this law. So the formative liberty, formally we have given this freedom. But can actually women walk on the road at the midnight freely? Can they do that? No. I mean, we will restrict, family will restrict, they themselves will fear, right? So, but not actually, or there is fear of safety or safety and security. Rape, India has been sometimes termed as the rape capital of the world. Many rapes are happening. This issue is there. So the point here is that yes, formative liberty is there, but what not there? Substantive liberty. So this is one way we are giving this formative liberty. The formative liberty has been given, but substantive liberty is still lacking. And that's why Gandhiji or Ambedkar are saying that the day in India, the women can walk freely on the road, that day I will consider we got the freedom. Till then, no. Formally we have got it, not substantively. Okay. Now the thing is, here the process of making the people actually exercise their liberty. You have to enable the system, right? You have to make women empowered, train them karate or something, or make the climate friendly so that the women can enjoy this liberty. Getting? So that action, when we promote the liberty, that is called as the positive liberty. That is, we are encouraging, we are making them to exercise their liberty. Positive liberty. However, negative liberty means that you do not put any kind of restriction on the women to walk freely on night. For example, let's say some government had put, I think in the that Kolkata rape case happened in that hospital. After that, there was a rule came that after 9 o'clock, women cannot go out. So that came as restriction. So when certain restriction has been there, and when you are removing that restriction, such restriction, it is called as a negative liberty. But when you are empowering them to walk freely, you are enabling them to do that, that's positive liberty. When you are removing the restrictions, it's negative liberty. Both are liberty only. But in one manner, we are removing the barriers. In another, we are enabling them. Right? Small difference, but there is certain difference. Right? So that is there. In India, we are following the positive liberty. Because negative liberty is already given in the formal sense. So our liberty is kind of positive liberty, where we are enabling women, different religion, to remain empowered. There is religious liberty is also there. We are not saying that okay, we have removed all restriction, that's enough. No. We are saying we are going to bring reform in the religion also, so that the religious practices can be freely processed. Right? So that education part is also there. So this positive liberty means enabling citizens to enjoy liberty. This is removing restrictions So this is enabling, this is removing the restrictions. So that is a positive and negative. Indian Constitution adopted positive liberty. Positive liberty. Just get out. Okay. Did you get that idea of formative and substantive? The same they can ask like the formative justice and the substantive justice. Formally, we all have this right to justice, isn't it? That we will be treated as justice. But substantively, we are not getting. The justice delayed. After 20 years, justice is coming. It's very costly. We are not able to reach. The justice system is very weak. Right? So, despite we have formally justice, but substantively, we are not getting that. So, that gap is there, and that is the role of the government to fill that gap. So that substantively we get this justice. There are some cases which promotes justice. This is more for the mains, not for the prelims. Like Anuradha Bhasin case, this is very popular, which said that right to access to internet is a fundamental right. Okay, this we will cover in because sometime UPSC asked like right to privacy is a fundamental right under which article? They have asked 2-3 times. So similarly, they can ask right to access to internet is a fundamental right under which article? Right. So this part will cover in the fundamental right. Just I gave for the context here, why in the news and those all things. So here see, this is what they are doing is that right to access to internet, that you enable that even the poor people or the rural people get the access to internet. That means you are ensuring the fundamental right. That means you are ensuring the justice. Second is that court issue directs to stop use of section 66A IT because it was restricting the freedom. So Shreya Singhal case removed this 66A of IT Act, which was killing the liberty of the people of freedom of speech and expression. This is negative liberty example, where we are removing the restriction by abolishing certain provisions in the law. But here we are saying that the bring more fiber cable or something, means we are enabling them to get their right to access to internet. Next, equality. Here, the meaning, two meaning is there. Number one, that whenever we say equality, means that there is equal access to opportunity. Equality doesn't mean that you treat everyone equally or you make everyone equal. That's not possible. What we talk is that let's give them equal opportunity, and based on their talent, their hard work, their skill, if they can grow, let them grow. But let everyone get the education. One person is getting working harder and becoming like a CEO or millionaire. We should not say that one person became millionaire, one person is poor. Where is the equality? We should judge the equality at the foundation. Are we giving them equal access to the opportunities in society and in economy, in the polity or not? Okay, so that is the equality we want. So here, what is equality means that equality of opportunity. Equality of opportunity in social, political, economic sphere. Example like equal access to education. Equal access to education. Okay, so that's the equality of opportunity. But the second thing is that absence of discrimination is also the equality. One is saying that you are making the equal, everyone equal. Second, absence of discrimination is also the second way of looking at it. The same concept, but another way of looking at it. Absence of discrimination or special privilege. There should not be any privilege. There should not be discrimination. Okay. Example: abolition of opportunity, untouchability. Untouchability. Even in the recently, like the demand for transgender rights, equality will come. First, don't discriminate against them. Give them equal opportunity to get the first. Don't discriminate. That suppose the job is, you have to choose for the job. Considering the person is transgender, you are discriminating, removing them. That's not fair. Another, then give the equal opportunity to everyone. So both comes under the equality. Here another term which is used, which was asked by the UPSC in the mains exam, which we should be aware, that is word called equity. This word equity. What's the difference between equality and equity? Yes, exactly. So the equity is nothing but equality plus fairness, isn't it? There should be equality, but it should be fair. Not like the absolute equality. If some people are unprivileged inherently or because of some situation which they cannot change, like the caste, they cannot change their caste, but because of the caste discrimination, they are unprivileged. So there you need to bring the fairness. So equality plus fairness is equity. So this is the equity concept. Any other? In India, what equality they have mentioned in the preamble? Let's go to the preamble. Yes, here equality of status and opportunity. Only status and opportunity. Two words are only there. Note down. In preamble or in front of that word only you can write, or separately also you can write. That would be better. Status and of opportunity. Only two. Status and opportunity. Only two. Remember this. Equality can be many. They can give the social, economic, political equality, something. It can confuse us. Let's be very careful. Just two words is there: status and opportunity. Okay. This equality word is there. Article, as we know, the word we got in Article 14 till Article 18. These are for the equality, right? Article 14 to 18 of the Part 3 Fundamental Rights. That we will cover anyhow. Next, what is caste-based work data? So 92% workers. These are for the mains. Indian plutocracy. These are for mains, not required for fraternity. When the fraternity word comes, our minds will go to the brotherhood, sisterhood also. Okay, brotherhood. Fraternity is more kind of a sense of, you can say that togetherness or belongingness, because it is reflected in the practices, but it's very difficult to judge whether one person is having the fraternity or not. If let's say one person is scolding another person, if you see from one side, that how can the other person become the aggressive towards the another person? So you will say that the lack of fraternity is there. But if you don't know the context, why he is scolding, what is the reason behind that words or the scold? If it is for the benefit of that person only, that you are not studying hard for the exam, you're going to fail, that is the intention. So there, it may not be visible to other third person that why he is scolding. He will see like he is scolding. So it's very difficult to judge. You cannot enforce this fraternity. It is the sense, it is the feeling, it is the psychological thing which has to be cultivated. It's a kind of attitude, right? So that's why it's a sense of belongingness. It's not like something which can be seen. It's very difficult. But still, some way we can see, like we see our fraternity whenever this war and other thing came. You must have seen, like when Operation Sindoor was going on, some interviewed, will you go if the country demands for your presence for the war? People said yes, and we will be happy to go. See, even for our village, if there is a requirement to fight, you have to fight for the country also. So that is the sense of belongingness, a brotherhood to protect the other people. So that is the fraternity. I think that way they can ask it. Now, this is promoted through single citizenship. Somehow, the single citizenship promotes, because one citizen, we are all, not the state-wise citizenship is there. Okay, any other? Yeah. Here, they have said that the fraternity with dignity of individual. What is the individually? Dignity means that it is inherent worth of being a human. It's kind of a respect. These are respect towards an individual. That is the key word. Their dignity word is also there. Okay, inherent worth. If you are a human, you are already having that worth, already having a value. You don't need to be something to get that value, respect. That's the dignity. You don't get that respect because you become something. If you start getting like that, that means you are violating the human dignity. That means when one person who is lacking the, let's say that the economic privilege, and then that person has been treated differently inhumanly, that's the violation of dignity. So fraternity, it should be with the dignity of individual. Like this Har Ghar Tiranga, some Kerala floods and Vijayawada floods, we saw some kind of thing. Unity of Trinity, here 3 words. Justice, yes, not justice. Liberty, equality, and fraternity. These 3 should be together provided to a citizen. Then only there will be the holistic justice. Overall development will come. So this is the equal is the foundation of social democracy. Not only the political democracy, but the social democracy. Not only political democracy, the actual democracy will come when all three things has been given. All three things has been. Now, only liberty is there. Equality is not there. Then what will happen? Some people will get the more privilege. If equality is there but liberty is not there, everyone is equal, but there is no freedom to do anything, then you can't innovate, you can't grow, right? And when the fraternity is not there, the people will fight among themselves. So all three has to be there. Then only you get the social democracy, and it has been said by the Dr. Bhimrao Ambedkar. So these were the different keywords, and now let's see the questions based on those keywords. What is it? Preamble. This is preamble. Mind of the makers of the Constitution of India is reflected in the preamble. Actually, these lines, mind of makers, very good lines to write in the mains. Okay, so we are going to give mains also, right? So we should be careful about this. Next. Both. One only. Two is not there. Not there in the preamble since beginning. Integrity word was there since the beginning. Integrity was later added, na? It's what it's saying. The expression unity and integrity. Integrity word was not there in the preamble since the beginning. So it's correct statement. Okay. This, what it is saying, expression unity and integrity. It's not saying word unity, comma, integrity. No. The expression unity and integrity was not there. Earlier it was only expression unity of the nation was there. Later, and integrity was added later. So this is correct. Not there in the preamble since the beginning. It was came in 1970. Getting? Yes. Next. Equality of status and equality of opportunity find mention? Yes. So both are correct. Now let's see that question. Research. Where is that file? See, that significance part we have already done. Now let's see the keywords questions. One of the implication of equality in the society is the absence of privileges. One of the implications of equality in society is the absence of privileges, restraints. Yes, restraint is for the, when there is absence of restraint, then liberty. Getting? So that we have to be careful in the defining. When it is saying that one of the implications of liberty in society is the absence of restraint. When it is saying equality, it is the absence of privilege. It's a small question, but become more careful. The more the sentence UPSC gives the sentences, it becomes easier to solve them. Never fear in the UPSC question when the question is long. The more the length of the question statement they are framing, the more loopholes you can find. More the shorter, be more careful. They will try to trap us in some manner. Okay, so don't make this 2 marks. Okay, please be careful. Democracy's superior virtue lies in the fact that it calls into activity C. A or C? What's your answer? C. Actually, this question should be dropped by UPSC. Why I am telling you? See, democracy's superior virtue lies in the fact that it calls into activity the intelligence and the character of ordinary men and women. Fair enough. We need the democracy can survive only when the men and women having the intelligence and the character both are required. Okay, to choose the right people. Otherwise, they will choose. If they choose the wrong people, then the democracy cannot survive. The methods for strengthening executive leadership, not at all. Executive, it's nothing to do with the, not directly anything to do with the democracy. Next, a superior individual with dynamism and vision. Now, a superior individual, this word is very, very subjective actually. Superior, how will you define? What is superior? If it is saying that an individual with dynamism and vision, somehow understandable. See, remember this kind of word, when it says superior, it's impossible to define. When you call superior, when one person gets the PhD or one person gets this much wealth, there is no definition. So it's like creating a privileged class, superior individuals. These are superior individuals. These are non-superior. So this is creating an issue. A band of dedicated party workers. This is not at all answer. Now, logically, if you will go, you should go with the option A. But here the catch is that ordinary men and women, this is not acceptable now. Because of the men and women are the two genders, transgenders. You cannot exclude that. So ideally, it should be citizens. If they have written the citizen, that's a better definition of it. So it depends on the intelligence and character of the ordinary citizens or the citizens. We can write men and women. It's not the right way to describe in the progressive egalitarian society like India. Next, which one of the following reflects the most appropriate difference between relationship between law and liberty? See the answer. A. B. Let's see. Which of the following reflects the appropriate relation between law and liberty? If you see, this topic is from, we read in ethics also. Law and ethics. When there is ethics, there is no requirement of law. And there is, say by Aristotle, there is, Socrates has said, when there is no law, there is no liberty. This is a statement by Socrates. Now, why it is, we will understand. If there are more laws, there is less liberty. Not necessary. Some law can enable us to get more liberty. No? Let's say the more law is there for the anti-sexual harassment, then the women get more freedom. So it doesn't make any sense. If there are no law, there is no liberty. Now, B is extreme. If there is, let's say the law is not there, that means state is not there. Will it be liberty? It's difficult in the political sense because in the politics, the human has been considered as the wild animals on the natural state. So if there is no law, they will kill each other's liberty. So that is the ideal, but still we should see other options. If there is liberty, law have to be made with, no, it doesn't make sense. It doesn't make sense. Like it can be made with representatives also. If law are changed too often, liberty is in danger. Why it will be in the danger if it is changing? I mean, if it is changing for the positive sense to ensure the liberty, should not be there. A cannot be there if there are more laws, there will be less liberty. You cannot justify this. You cannot justify this. Does that mean we have the more article 360, around 400 articles are there? Does mean the less liberty is there? US has less law. That means they have less. So that relation you cannot establish. So option B makes more sense here. If there is no law, no liberty. Actually, this is the statement of Socrates. Law is important to ensure the liberty of the people. Remember, this is the polity, okay? Polity subject. So from that point of view, don't take like the just philosophy or something. Is in the context of the polity, which of the following best explain the most appropriate definition of liberty? This. D. Opportunity to develop oneself fully. Again, you cannot define fully. That means if you are not able to develop yourself fully, can you say that I don't have liberty? Fully means what? See, these kind of adjectives or adverbs they are putting intentionally. Here, this is the protection against the tyranny of the political rulers. This is not right. This is not tyranny of protection. Protection against the tyranny of political rulers. This is not tyranny. Can be absence of equality also. Liberty may not necessarily be there. Suppose they are giving liberty, but some people has been discriminated. So equality is more appropriate for this. Opportunity to do whatever one likes. This is absolutely wrong. Opportunity to develop oneself fully. It is also actually, to be honest, the B and D can be there, but because of this fully word, I won't choose it. What? Opportunity to develop. Opportunity word is dominating the word fully. Opportunity to develop oneself fully. Yeah, maybe B and D, anything can be right. My take would be absence of restraint. Yes, it is also not completely defined. The issue is that because there are reasonable restrictions that has not been mentioned here. Not like the complete restraint. Opportunity to develop oneself fully. Maybe that can be the possibility. See, this kind of question will be subjectivity will be there. We cannot define exactly, right? It depends on the interpretation, like how UPSC have taken answer. We have to check in 2019 how they have taken the answer. Once we'll check this. Okay, so this which are the following factors safeguard of liberty in the liberal democracy? Committed judiciary, centralization of power, elected government, separation of power. Which of the following factors constitutes the best safeguard of liberty in liberal democracy? B and C you can easily eliminate. Centralization of power cannot do that. C, elected government, not necessary. No? I mean, if they are not elected also, they can safeguard the liberty. Then comes the which of the following factors constitutes the best safeguard of liberty in liberal democracy? Yes, in the liberal democracy, elected government, not necessary. After election also they can become the tyranny. A committed judiciary, a separation of power. What is meaning of committed judiciary? which saves the rights of the people, but who goes beyond the separation of power also. When there are another word called as the committed bureaucracy. Committed bureaucracy are those who are more committed towards their loyalty towards the political and this their loyalty, basically more committed towards that. Yeah, maybe possibility. So that may not always promote more liberty. If committed judiciary is there, let's say, so if they are protecting more and more liberty, then others' liberty may be violated. Maybe the committed judiciary is not a very positive term. Committed judiciary. Yes, the committed judiciary is not a positive term. See, if they start doing, they may violate to protect the rights of something. They may violate the rights of other. For example, Aravali case. In order to protect the environment, let's say they focus on the environment, then the rights of the people who are living there may be violated. If they protect the economic rights, then the rights of the other environment will be violated. So the point here is that there should be the separation of power which establishes the best liberty. That means separation of powers between judiciary, executive and legislature. So both take care, all three take care about the liberty in a balanced manner. I think that should be the best safeguard for the democracy, liberty. If the committed judiciary is there, there may be a point when they start taking up the liberty of the people. That's possible. What this in some country they are making the judiciary more powerful, then it is the problem. So, but when there is separation of power, one will check the other. So liberty can be safeguarded. Best way to safeguard. So option D should be the most reasonable answer. No, it's not related to federalism. Separation of power. Federalism means center state. Separation of power is between the legislature, executive and judiciary. Right? All three have the responsibility to protect the liberties of the people. The legislature will make the liberty, right? Law. Remove the discrimination. Executive will implement it. Judiciary have to safeguard whether the implementation is happening as per the law or not. All three have the responsibility. One cannot ensure the liberty. Right? All three. One has to make the liberty law, one has to implement the liberty law, another has to ensure it is as per the law. Okay, that is why they should have the separation of power and they should together implement it. Okay. This is the important there. We should do this. PYQ analysis is now very important. If you go only with the book now, it's very difficult because the questions are deeper compared to the not like the directly coming from the book. It's not. Okay, so these are the preamble. Now next subtopic we'll take a break and then we'll start fundamental rights. Okay, we'll start the fundamental rights. We'll first analyze the fundamental right, what type of question they're asking, and then we'll go to the next, the covering of the topic. Let's save this. Okay, so first let's analyze the PYQs, then we'll create the syllabus for like the same only, but just like in what structure we are going to study them based on the PYQ. Now the first is that when we analyze this subtopic of fourth subtopic, it is going to be under the constitutional framework, that is the fundamental right. One type, again we are getting the same thing, is that they are asking on the features and significance of the fundamental right. Right? For example, which one of the following statement is correct? Like the rights are claim of the state against the citizen. Rights are privilege which are incorporated in the constitution. The point here is that it's not a particular right it is talking about. It's all about right it is asking. So we need to understand about the right first. So that is the feature. Now here, which of the following envisages that the right against exploitation in the Constitution of India? It's nothing but the provision, I think. Yes, articles and provision. That is the second type of question they are asking, and it is the most important type because more questions are coming from them. Next, third type is the right outside the part 3. There are certain right outside the part 3. Example, right to property. It's outside the, but still a right. Right to vote, right to get elected. Right? These all are also right, but not in the part 3. That's also they are asking. Then reads, enforcement of the right. Reads are enforced by the judiciary. What are those reads and how they use? That has been a major question UPSC is asking. Mandamus and these prohibition. So what is the differences? That is the next type of question they are asking. Then we'll come to the DPSC later. So what we identify in the this fundamental right chapter is that so the our subtopic is going to be fourth, right? Fourth, that is fundamentals rights. Within this subtopic, we're going to cover some micro topics. Number 1, that is MT1, is going to be the features and significance of fundamental rights. Second, micro topic 2 is going to be the articles and provisions. What are the provisions? That is the thing we are going to see. Third, micro topic 3, rights outside part 3. Fourth, micro topic 4, that is writs, prerogative writs. These are the 4 micro topics we are going to cover. Okay, now let's start with the first micro topic 1, that is features and significance of rights. The first point number 1 is that what is right mean? Now, right means these are nothing but the set of conditions, which enables a person an individual to achieve its potential. See, potential can be less high, but rights are something which enables us by giving us equality, liberty, freedom. These all things they give us so that whatever potential I have, I should be able to achieve that, isn't it? So in simple manner, this is nothing but the condition which enables an individual to gain their potential. Okay, this is the right. Now these rights can be have the different types, right? By birth we have certain rights which are called as the natural rights. Natural rights, that is, by birth as human we get certain right. Example, right to life, isn't it? Right to life we have. No matter whether I am a citizen or not, I got birth as a human, I get certain right. Right to right. Natural rights. Okay. There are moral rights also. We can also say that the 2 is the moral right. I have, see now, as a father, I have moral right to punish or my child. Right? This is basically non-enforceable rights. Example, father's right to take decision about minor child, their career. They have this right. It's not like the what decision they are taking, you cannot legally enforce, isn't it? So that is moral right. Then third comes is the legal right, which are enforceable in nature. Enforceable in nature. Okay, these legal rights can be of different types. It can be our political rights, right to vote, for example. It can be our civic right, like right to expression, thought, right to thought and expression, It can be social right, like equal, maternity benefit, let's say. Fourth, it can be economic right, like right to profession. So that legal right can be political right, can be civic right, can be social right, can be economic right. See, these are may not be directly asked by the UPSC, but these keywords, this classification help us to broaden our mind about the rights. It will help us to think about this right in a broad manner, so that we can eliminate the options, and sometimes the question can be on the moral right and these legal rights. Now, next thing become important for us to see the enforceable rights. In Constitution of India, or let's write as in India. The enforceable rights in India. I mean, we saw these rights overall. Now we are seeing in India. In India, we have the 3 different types of right. One is the fundamental right. Second is called as the constitutional rights. And third is called as the legal or statutory rights. Now, this difference has to be well understood. What is the meaning of fundamental right? What is the meaning of constitutional right? And what is the meaning of legal or statutory rights? Number 1, 2, and 3. So, now, when we say that the fundamental right, these are the specific rights. Rights are many, but these are specific rights which are in the part 3 of the Constitution. Rights which are there in the part 3 of the Constitution. These are those rights which are outside part 3 of Constitution, but in the Constitution only. In the Constitution, but outside the part 3. Third are legal or statutory right. Legal right which are not part of constitution, but right by law, ordinary law, ordinary law. That's the difference. Now here, for example, Article 14, equality before law is an example. We know that we are going to cover. Here we have this Article 300A. What it is? Right to property. Similarly, right to vote, right to get elected. Here, example is Right to Information Act 2005. It gives us what? Right to information as a legal right. Similarly, right to education, that has been included as 21A. Right to food through the Right to Food Act 2013. Manrega used to provide the legal right to get the 125 days work. That's a legal right, not the constitution, not the fundamental right. Now, when you know that this is a part of Part 3, the amendment changing the rights, abolition of the rights will be here. That is, the amendment would be difficult. Requires Article 368. This is amendment is easier, and this is much more easier. For example, Manrega Act, they changed it without much protest, but taking away Article 21, 20, these things is going to be tough. They need the support of Rajya Sabha and those special majority, and those things required. Now, for enforcement, next point is the enforcement. Like how these are enforced? These are enforced using Article 32 and 226. This is the article through which the Supreme Court enforce it, right? They issue the writ. This is the article through which High Court enforce the fundamental right, issue the writs. Here, yes, these articles can be used, but not as a fundamental right. Not as a fundamental right. You can, if any of this Part 3 article is violated, I can directly go to the Supreme Court using Article 32. Here I cannot go. That's not my right. They can entertain. They know hard and fast rule like that. But I cannot claim it as a right. In this case, they cannot refuse me that you go to the High Court. They cannot do that. They cannot refuse to take my case. But in this case, they can. Not a fundamental right. So, Article 32 not as a right. It cannot be claimed as a right. Okay? Because Article 32 itself is a fundamental right. The Part 3 only. Isn't it? So, it cannot be claimed. These are enforced through civil laws, civil and criminal laws and courts. Like they can ask you to go to the session court, municipal court, or some court. Here CRPC, IPC, not that, on DNS, DNSS, these things will be applicable. And for that, they are going to use them. Okay? So clear, this is the very important part before entering into the fundamental right. You should be clear with this rights. Now, this is the next feature. We understood the types, we understood what is right, we understood the types. Now see, the rights envisioned by makers of constitution. See, our constitution makers envisioned a lot of rights. There are so many rights are required. Right to form cooperative, right to get good agriculture, scientific agriculture, right to get good healthy environment, right to get equal pay for equal work. So many envisioned. However, the resources was not there that much to implement and ensure all the rights. Right. So our constituent advisor, who was the constituent advisor? Can you remember? Yes, B.N. Roy. So the Sir B.N. Roy suggested that let's divide the rights, because we cannot fulfill all the rights, into two. One is the enforceable right, one is the non-enforceable rights. So they divided due to lack of resources. Rights were divided into two categories. Rights were divided into two categories. Now, category 1 was the enforceable rights. And category 2 are non-enforceable. Non-enforceable rights. Now, the enforceable rights are the fundamental rights, which were included in part 3. Part 3. And those which cannot be enforced now was kept as DPSP, as part 4. So that whenever the resource will permit, we'll bring it here. Example, earlier the right to education was in the part of DPSP. But when we felt like now we can provide the 6 to 14 years age children the right to education, we brought it here. Right? So that is possible. That is possible. So here, this is enforceable, this is non-enforceable, this is the next point. Next. Okay. Now, other key features. This you write it. Number 1. Their goal is, remember this here the goal is more to ensure political democracy. Political democracy. Objective is to ensure political democracy. Here it is social and economic democracy. Because you see the provision more of like the bringing the social equality, economic rights, like equal pay for equal work, like the giving the labor class right to participate in the management of the companies, factories. So this is, but this is more political. When you get the assembly association wala part, na, that means you are getting the right to create a political party. Comes from Article 19. Freedom of speech and expression, that I have this right to vote. Until unless I don't have that right to have this freedom of speech, expression, conscience, and these all things, I can't participate in the political party, political things also. So the objective of part 3, fundamental right, is to ensure the political democracy. We try to achieve the political democracy. Here we try to achieve the social and economic democracy. Right. More, it's not completely segregated. Article 17, abolition of untouchability, it's a social democracy. But largely when you see this, you will find like it is to ensure the political democracy, that is the let the people participate more and more in the law making, politics, and the rule of this country. The second is, these are the fundamental rights are first, these are enforceable. Yes. Okay. Point number 1. Point number 2, these are available against state. Most are available against state, but some are also against citizens. Some are against citizens, and some are also against legal entities. What is legal entities? Now here let's cover the subtopic here. What is legal entity? Any non-living thing or any non-human thing which has been given as a legal body, identified as a legal body. When I say that anything has got the legal body, let's say it has been declared as a legal body, means what? The action of this body can be sued on the court. It can be asked to come and give explanation. It gets rights. It gets duty. So if this does anything wrong, we can pull it into the court. Similarly, this can, if somebody, you violated its right, it can go to the court and sue you also. That's legal entity. Example, river. River Ganga has been identified as a legal entity. Means what? If river Ganga is polluted, Ganga can go to the court. How? There will be some welfare association, they will go on behalf of Ganga, they can claim. Second example, company. Company is not a human, right? But still we can sue the company. Not a person there, the company. The representative of the company will go and reply in the court. So the company is a legal entity. So the company also gets certain rights. We also get rights against the companies also. Okay, so the legal entity, something which have the legal validity, that is, they have the validation of legal validation, can be sued or gets rights and duties. Example, companies, rivers like Ganga. Some temples also have got the legal entity. So that also we have to remember. This is not only on the citizen or the state. Some are also against the legal entities. Okay, clear? Third point, it is against the tyranny, against the tyranny of state. That example, for example, that bulldozer justice. Bulldozer justice, you know, right? Whenever there is riot or something, then government will take the bulldozer and destroy the whole family house, right? That's called bulldozer justice. That violate Article 14. So if let's say Article 14 is not there, then what will happen? They can do anything, right? Court can also cannot do anything because there is no protection against a certain thing. But the fundamental rights prevents this kind of tyranny of the state. Okay. Next, this tries to achieve government of law. Then government of person or individual. Means what? The government is ruled by law, not the individual's whims and fancies or their willings. Fifth, there are reasonable restrictions, not absolute. Are they permanent? Are the fundamental rights permanent? Or can be taken away or removed? We cannot take away the fundamental rights. Emergency we can take, right? As well as, can we amend them? Can we remove any fundamental right? Let's say any article, let's say the 18 or something. Yes. So that means these are not permanent. These are what you can say, not permanent or permanent or sacrosanct. Sometimes only, but only except the basic feature. Except the basic features. Other are not permanent. Seventh is, these are in positive as well as negative in nature. We know this, what is positive, what is negative. Then can be suspended during emergency. I think these much features are enough. We have covered extensively almost all the features. Okay, next. Let's start with the first, that is Article 12. We covered, sorry, let's go to the micro topic now. 2. Micro topic 2, that is articles and provisions. So the first is done. The number 1, first we'll go with the Article 12. Article 12. What does it do? This article gives the definition of state. This gives the definition of state. Now the question is, who are state? Let's go one by one. Number 1, legislative, executive, LE, legislature and executive. Yes, they are state. Legislature, executive are the state. What about local bodies? Yes, state. Okay. Executive covers all, permanent executive as well as the temporary executive. Okay. Third, judiciary. Is it state? Remember, as per the Supreme Court judgment, it's if the judiciary is performing judicial task. Yes. If performing, yes, administrative task, we have to segregate this two. That means if it is performing the judicial task, it's not state. It's state. As per the definition of Article 12. Okay, these pointers are important. Now, fourth, what about the private bodies? Private bodies or companies or institutions. See, I was working in one NGO for 4 years, 2017 to 21. That NGO name is Pradhan. This NGO was registered under the Societies Registration Act 1860. Okay, this is a private body. It's not a government body. It's an NGO, non-government. Itself is saying a non-government organization. So this Pradhan, will it be called as the state or not? Yes. So Pradhan is like this NGO is not a state if it is a private body. But we had this MOU with the state government to implement one scheme called as a National Rural Livelihood Mission. Now this is the government scheme, and they made us, because we have the strong, the relation with the people in the Bastar. I was working there. So NRLM, we became the implementing agency. On behalf of government, we were implementing NRLM. Now when we took this NRLM, now we are implementing it. We became what? State. Clear? So until and unless the private sector is not having any function to enforce or to implement something which is related to the government, that is state, it won't be called as the state under Article 12. The moment it has started working like a government by implementing or taking certain schemes like this, they will be called as the state. So the private institution, if involved in implementation of any government function, then state. The last is the international bodies. Are they state or not? An international body as per the Supreme Court and High Court, like UN, are not state under the definition of Article 12. They are regulated not through our law but the international law. So they are not state. International bodies. So this much is important. Mostly the question can be, if they ask which among the following are state under the definition of Article 12. So we should be clear. The more confusing with the judiciary, international body, we can get confused. Private body, we can get confused. Other, we won't get confused. Okay. Next. Article 13. Now it says that, simple thing is that law which violates any right under this part. Which part? Part 3 would be void. Okay, would be void. This is the thing they have mentioned. Now here, how they will make how law would be identified as violating of fundamental right. It will be using Article 32 or 226 by Supreme Court or High Court. They can say that this is the null and void. The lower courts cannot do that. Only Supreme Court, High Court, because these are two articles provide them that power. The third aspect we have to know here is that Article 13(4), Article 13(4) clearly say the Constitutional Amendment Acts are not law under Article 13. This we have already discussed, right? These are not law. That which amendment they made this? (40) Yes or no? Before that only, 24, 1971. They made this provision that this Article 14, the Constitutional Amendment Acts are not going to be called as the law under Article 13(4). Okay, so but they can be challenged. Okay, that we know are not law, but can be challenged if violate basic structure as per Kesavananda Bharati case 1970. Okay, but it's not like they are not law. That means if they take away any fundamental right, even if take away any fundamental right or violate any part of any provision of this part, it does not mean that they cannot use Article 32 and 226. If it is found that this Amendment Act is violating any fundamental right which is part of basic structure, then Article 32 and 226 can be used to make them null and void. Okay, so till now for our country only this basic structure is protecting from the state. Otherwise everything can be amended. That's the power of that doctrine. Okay, let's not go into detail. Any other point here? No. Next, Article 40. Here two things are there. One is that equality before law and equal protection of law. Okay, equality before law and equal protection of law. So the state has to ensure, right? State must not deny equality before law and equal protection of law to its citizens, to the people, right? Is it only for the citizen or anyone? Anyone. Only Article 15, 16, 19, 29, 30. So, state must not deny equality before law and equal protection of law to people. That is even for non-citizen. So these points has to be very clear, okay? Very clear in our understanding. Here only we make mistake and lose marks. And when you read the question, be very careful about these aspects. So equality before law and equal protection of law. Now here in this particular segment we have to cover this as a difference. Equality before law and equal protection of law. First let's understand what are these things and then we'll come to the other facts about them. Number one, it has the three meaning. You can say three meaning. 3 points we have to remember here. First is no privilege class. There is no one above this. Absence of. Let's write same word. It becomes easy to remember. No privilege in front of law. No privilege in front of law. Second, no one above law. Third is equal subjugation. Equal application, that's right, to all. See, I'm not using exact terminologies, that's not required, but the sense is same. Okay, equal application to all. That means there should be no special class, no one above law, equal subjection of everyone in front of law. Okay, exact terminologies are I'm not writing here because not required. Our understanding is more important here because we have to eliminate options, not like the right answers. That's not the objective. So no privilege, no one above law, equal application to all. Now here also there are three meanings. Number one is equality of treatment under equal circumstances. So first one is that equality of treatment. Here this term is important, under equal circumstance. That means when there is same circumstances only, we have to treat them equally. If they are in the different circumstances, one is underprivileged already, one is privileged, then you don't have to treat them equally. Second, similar application. Similar application of law. That means when you are taking away the law, when you are punishing, then also use the same law, the same kind. When you are giving privilege also, do the same. It should not like the in terms of privilege you are treating differently, in terms of punishment you are treating differently. So similar application of law. Likes should be treated alike. Like should be treated alike, and unlike should be treated alike. That means same kind of people should be treated in same manner. Equality of treatment under equal circumstances, similar application of law, like should be treated alike. They bring almost the same meaning. But the thing is, sentence if they create, we should be aware. This is called as the negative perspective of rule of law, and this is the positive. This is the British model and this is American model, and we have adopted both of them. No privilege, no one above law, equal application, equality of treatment under equal. Why it is positive? Because it is not like the hard and fast, like the equally you are applying everyone. Here we are considering the aspects of their background, whether they are situated in the same situation or not. Exactly like that, one person who is healthy, fit, another person who is not having a leg. Both are not like. So you cannot treat them alike. If both are like only, in the same only, then only you can treat them equally alike. But if both are unlike, that is the different, you have to treat them differently. That's the positive aspect. But this aspect is you have to treat in front of law everyone equally. Okay, so that is the two aspect. Here in this article 14, we have to also bring about two words. One is called as a rule of law. Another will come as a rule by law. So first let's talk about this rule of law. Article 14 is actually the reflection of rule of law. This concept has been given by A.V. Dicey. He gave this concept. As per his concept, there are three things, three aspects of rule of law by Dicey. Number one, no arbitrary power. No arbitrary power means, that means the power should be exercised based on certain law, fixed law. Power based on fixed or the due process of law. Second, no arbitrary power. Second is equality before law. Equality before law, this we have already covered, equality before the law. Then third, primacy of rights. That means rights are important. And what it says, it says that constitution is the result of rights of citizens, of the people. That means constitution has come because of what? Because of rights. So in India, we have adopted the first one. Yes, we have adopted second one, but we have not adopted the third one. We have not adopted this. The third one, here we say that in India, here the change is, in India, rights are outcome of constitution. In another word, rights derived from constitution. Constitution or constitution as a source of rights. Source of rights. Constitution as source of rights. In India, rights are outcome of the constitution. That means rights are coming from the constitution. One is that the right is the one who is making the constitution. Another is the constitution is bringing the right. So that's the difference. So this point we have to remember here. This ABDIC concept 3. No arbitrary power, equality before law, right primacy. Here what primacy? Constitution primacy, right? This is constitution primacy. Constitution is the key because that is the source of our rights. Next is your reasonable restriction. Reasonable restriction are there. Restriction, that means these are not absolute. There are exemptions or restrictions or exemptions. Exemptions has been given. We are not treating everyone equally. Now we are giving certain privileges. President has certain privileges. Article 361, for example, Article 361 gives the privilege to President. Right, this is one privilege. There is Article 105 which gives the privilege to MPs, Parliament. There is Article 194. Article 194 privilege to MLAs, UN and UN members, its employees, its sovereign diplomats, they get privileges. So there are certain privileges given to the different section. Okay, so these are the exceptions. There is one interesting exception which is Article 31C. So what Supreme Court has said, whenever Article 31C comes, Article 14 goes away. Means that whenever Article 31C is coming, that is this is related to land reforms. This is land reforms related article. So whenever they have to do land reform, they have to treat the different people differently, right? So the article 14, which says that the equality before the law has to be violated. You have to give certain people more privilege using article 31C, right? So that's why Supreme Court said, like, whenever article 31C comes, article 14 goes away. And it is how it is justified. It is justified because of the balance between the fundamental right and DPSP, which was established by the Supreme Court in Minerva Mills. We don't see the fundamental right completely different than the DPSP. We have to see them by bringing the different provision together. And when we bring this different provision together, we find that it is valid. That was the justification given by the Supreme Court. Otherwise, how can you? The debate was this, like which one should be prioritized? There is a priority to DPSP or priority to your fundamental right. And this land reform was to implement Article 39. Article 39. Article 39 B and C. Clause B or C. These two are to ensure the land reform, basically to prevent the concentration of wealth and the equal distribution of wealth. That is nothing but land reform. Prevent the concentration of wealth means prevent the concentration of land. Equal distribution of the wealth means distribute the land, right? So this is Article 39B and C, which is a DPSP. Now, you know the Article 31C is introduced through the amendment to bring this reform. Now, to implement this came, and whenever Article 31C comes, it has to compromise yourself. 14. It is only to establish the balance between DPSP and the fundamental right. You cannot give more focus to DPSP or more focus to the fundamental right. It is based on the balance, and that's the Minerva Mills tries to establish, and that's why currently we don't have any dispute. See, earlier so many disputes happened between these two. After this Minerva Mills case, recently we have not seen dispute between the DPSP and the fundamental right because it is well established now. Okay, so these are the things which are there in the fundamental right, Article 14. This is Article 14. This is about the rule of law. This is also important. These two concepts, Article 14, 13, 12. Okay, let's quickly see. Today we'll close the class. Actually, I'm having some health issue today, and then we'll start tomorrow. So we'll have to finish it today. So let's quickly see this, then we'll close today. Okay. The subtopic is the fundamental right. We have divided these three things, four aspects. We have already covered here. We are here in Article 14. We have covered. The rest of the articles we'll try to cover in the next class, and then these aspects also. So within this, the first one is that you see your notes. You have to see that. See, one thing you remember the strategy whenever you write any test. Suppose you're writing any test, and you got some issue. Let's say the question was on the significance of the fundamental right. You found you could not solve that question. You made mistake. Generally, what we do, we see the model answer, right? Don't do that. We have to see the model answer, but go to your notes. You have to rectify your mistake by seeing your notes only. That's why I asked, if you had couldn't tell that B and Rao, no? I would have asked you to go back and see. Instead of I tell you like it was B and Rao. Because unless you won't see that again and again and again, that picture won't come in front of you when you will write the test exam. So we have to make sure that we revise, we update our notes by going back to it. So this Saturday, I think we are going to write test Sunday or Saturday. We'll write test based on whatever topic we have covered. So there will be, you will find like some question you could not solve, some question you made mistake. So model answer will be provided, but my request would be not to completely rely on the model answer. You have to go to your notes. Okay. If you solve the question, it should be from your note. If you are making mistake, it should be rectified in your notes. And if let's say you are getting any new point, update your notes. Okay. So the primary source would be your notes. Generally, we make that mistake in mains also, in prelims also. We should make sure that we see them. So whenever we revise, try to see your thing. See, first one, significance. These are very basic. Moral right, natural right, and these things. Legal right, it's very important. This fourth, this is also very basic. This is important. Question can be framed here. Fundamental right, constitutional right, legal right. Only difference is that enforcement and where they are situated. Next is rights envisioned by the makers of the constitution. Enforceable, non-enforceable. B. M. Rao has suggested this. Other key features, enforceable, we know this. Second, against the state but not necessary. Some are against the individual. For example, untouchability. Article 14, can it be applied against the individual? Can I see? The thing is, suppose you and me have certain interaction. I said like let's say I have my company. I don't want you. I want to prefer her in job. Can you go and sue me in the court? Should it be allowed? Like suppose I want to have tea with you. I preferred you instead of her. Can you apply here? Like you have not treated us equally, sir. You took one person. Is it possible? No. Remember, equality of law and equal protection of law when it is saying against the law. Individuals cannot make law. So somebody has made the law. Now, if they are not following the law, that means it has to be claimed against them. Individual citizens are not the one who has to enforce the law. So, how can you go against me to sue me at the court by saying that he has not protected my right? But if I am a legal entity, then you can go to, suppose I am a legal entity, I should protect your equality, let's say, that is being given as per the law. Then you can claim. But individual citizens, if they are treating differently, you cannot claim that. Right? So, Article 14 is available against the state because they are the one who are making the law. Right? Similarly, this fundamental right, equality before law and equal protection of law is, remember, it's against the state, not individual. But Article 17, which is a DPS, which is against the untouchability. Even I am practicing untouchability against you, saying that if you are sitting here, I won't come to the class because you have belonged from one caste. Then that is, you can claim against me also. Getting the difference? So there will be, we will create a list at the end. What list we will create? Which are available against the citizen? That part has to be. Everything is available against the state. But some are only available against the individual. So that should be a separate note we should be having. Otherwise, if you cover for everything, it will be confusing at the end. Okay, so that we will try to do. That I'll bring as a separate note so that we can use that. Today we'll close this half an hour before. I'm sorry for that. Actually, I am having such an issue.